Hello, everyone. Welcome to SNIPit3 live conference. I'm Ansam Okbani. I'll be your host today. Today's session is on electronic bills of lading, and we'll be hearing from three experts on this subject. First, Manuel Alba, Associate Professor of Commercial Law at the University Carlos III of Madrid. Hello, Manuel. And
Hello.
then Wacher Kjærgaard, Digital Lead at BIMCO from Copenhagen. Hello, Mas.
Hello.
And finally, Javier Franco, Director of the Logistics Observatory of the Externado University and partner at Franco y Abogados from Bogota. Hello, Javier.
Hi, Ansam. Hi, all.
Each of the speakers will provide his views in 3 minutes, and then we'll have a 15-minute Q&A session. You can send your questions in the chat. All right, let's get started. First, Manuel, can you please provide us with an update on the countries enabling digital documents and on international conventions?
Yes, thank you very much, Ansam, for the invitation. Now, as you know, a proper ecosystem or environment for the use and consolidation of electronic bills of lading needs, of course, a proper legal framework. Such a framework has been, in fact, one of the long-standing demands of the maritime industry since the late 90s, more or less. One thing we have to take into account and to keep in mind in the end is that generally, digital negotiable documents of title and their use in many countries need to be explicitly recognized by the law to have the proper and expected legal effects. Now, if we try to provide a landscape of existing laws recognizing and regulating electronic bills of lading and their effects, I think we can group them in three blocks, let's say. Now, first, we would have the national rules that pioneered this field in the early 2000s or late 90s as well. Second, international instruments addressing the said needs. And third, what we may call the second generation national provisions that were approved after all these previous instruments. Now, the most prominent national law instrument that addressed electronic bills of lading around the year 2000 or a bit later than that is I would say Article 7 of the Uniform Commercial Code of the United States, which is being actually implemented in quite a number of US states and is enforced there since quite a long ago. Shortly later, and more or less following the footsteps of the UCC, some international instruments address also the issuance of electronic bills of lading. These particularly include, in the first place, the Rotterdam Rules of 2008, which is the UN Convention on Contracts for the International Carriage of Goods wholly or partly by sea, and shortly later, the Mother Law on Electronic Transferable Records. Both of them are ancestral instruments, as you surely know. Now, while the Rotterdam Rules specifically address electronic negotiable transport documents, such as electronic bills of lading, the Model Law addresses in general electronic transferable records, including but not only bills of lading. The Rotterdam Rules have not entered into force yet, but several countries have passed national laws based on the Model Law on electronic transferable records. Actually, the result of both the Rotterdam Rules and the Model Law are essentially the same. These national laws approved after the Model Law was finished are what we may call the last wave of laws addressing the electronic bills of lading. Countries, for example, approving these laws include some important nations from the international trade point of view, such as, for example, UK, France, or Singapore. Now, looking at all this, and at the international level, this does not probably provide yet for the ideal critical mass, let's say, of laws needed for uniformity, but at least they show a tendency that will probably allow getting there in the close future. One very good thing about all these national and international instruments, I would say, is that they show quite a consistent and common approach to the regulation of electronic bills of lading, particularly in 2 points. First, as the cornerstone of their scheme, all of them are based on control of digital documents as the equivalent of possession of paper ones, which has always been the basis for holdership of bills of lading. And second, and at the same time, they have been formulated in a technology neutral way, which has allowed to satisfy the conditions they state using different technologies over time. Initially, centralized platforms and later distributed ledger technologies and blockchain-based solutions. Now, I would say these two ideas or principles will very likely continue to inspire the rules that we shall see probably in the future as well. So with this, I finish. Thank you so much, Ansam.
Thank you very much, Manuel. Mas, hi again. What is the role of BIMCO, and do you have some success stories that you can share with us?
Yes, absolutely. And thanks for having me once again, Ansam. Yeah, so what is the role of BIMCO? Because obviously we don't issue or receive any bills of lading, but our members do that, and they do that quite a lot, in fact. As an organization, we believe at BIMCO that e-bills are a really good thing and that it presents major advantages for our members and really the shipping industry on a whole. We think that e-bills are safer, faster, and greener. It's a better alternative in all ways to the traditional paper bills of lading. More specifically, our role is to spread the word about why e-bills are good and share knowledge and know-how and success stories. And one of the ways we have been doing that was when we, back in 2023, launched a campaign to try and really encourage more of the industry to take a closer look at e-bills and start using them. That campaign was called the 25 by 25 campaign. And as part of the campaign, shippers could commit to moving 25% of at least one commodity on electronic bills of lading by 2025. And the campaign had support from some of the world's largest mining companies, among others. And we were really, really pleased last summer when the initial 4 participating mining companies, shippers, BHP, Rio Tinto, Vale, and Anglo American, managed to reach the target for their iron ore, as I said, already last summer. So that's 6 months before the target date. And these 4 companies account for something like 80% of the world's total iron ore production. So it's really quite an achievement, which goes to show that widespread adoption of e-bills is not some far away distant future. The future is now, you could say. And we're also talking to many other shippers and commodity traders that are managing to do 80% of some commodities on e-bills. And we have even heard 100% of certain commodities being done by companies on e-bills. We, of course, want to retain this momentum and continue to spread these positive stories about the adoption of e-bills. And we have a focus on expanding into other commodities, and we're starting to see some really great interest from, example, the grain trades. Another part of our role is the development of standards to support this transition. So development of standards are part of the BIMCO DNA. We have been producing paper standard bills of lading, charter parties, much more for over 100 years now. And that's also why we back in 2022 launched an open and completely freely available EBL standard. And the last point I just really briefly will touch on is, of course, engagement with stakeholders, trying to bring everyone together and see how we can overcome whatever challenges might be there. And that is why we are founding member of the Future International Trade Alliance, or FIT Alliance, where we work with ICC, DCSA, SWIFT, and FIATA to try and work on challenges together with all stakeholders. Thanks, Ansam.
Thank you, Mas. Javier, hey again. You are muted.
Sorry, thanks, Ansam. Yeah, well, I will try to provide a very brief perspective on what's the situation in South America.
Thank
So
you.
basically, I just want to mention that, I mean, Manuel has briefly referred to the conventions. I just want to start by saying that in South America, we have like Hague countries like Argentina, Hague Billy countries like Ecuador or Mexico, and some others like Hamburg rules countries like Peru or Chile. And then the question could be regarding, specifically the situation of the use of electronic documents, whether their national laws have incorporated, for instance, the UNCITRAL model law on electronic commerce, which was the previous to the MLTR. For instance, that's the case of Colombia, Ecuador, and República Dominicana or Dominican Republic. That's the case. So if you think about what country has also any kind of regulations that either allow physical paper to be equated somehow with electronic documents in the region, you will see that countries like Chile, Panama, Ecuador, even Mexico, and of course, Colombia, we do have some regulations, for instance, equating somehow the use of paper-based documents to electronic documents. So I just want to make a brief reference to the Colombian case in the time that I have today. So basically, what's the situation in countries like Colombia? As I have said, some countries in the region have incorporated somehow the parameters of the UNCITRAL model law on electronic commerce. But then, there is a catch there because in Colombia, we also have incorporated the two articles referring to the specific situation of the contract of carriage. And that's something we need to address now, because in those two articles, basically what we have in our current legislation is that acts basically related to the contract of carriage could be somehow replaced by, or you can use either paper documents or be replaced with a data message. So basically, in countries like Colombia, you can actually use a data message as opposed to say, a paper-based document. And if the document is incorporating rights, like a bill of lading, then you just need to be careful about using a reliable method to guarantee uniqueness. So in a way, what I can say is that some countries in South America, like Colombia, we have already a way to use, electronic bills of lading, and the legal framework, in a way, is prepared for that. But then we could obviously improve our way forward, like with the adoption, let's say, of the Rotterdam rules, or the incorporation into domestic law of the MLTR. So that's the challenges ahead. But at the moment, that's the situation in some in a
Okay.
very percentage.
Exactly. Thank you so much to the three of you, Javier, Manuel, and Mas, because I know it's a real challenge to speak so briefly. You did it very well, the three of you. Now we're gonna proceed with the Q&A session. And I have a question for you, Manuel. Can you please explain briefly, the Q&A session will last 15 minutes, what the functional equivalence is?
Okay, now the functional equivalence is one principle that has very significantly guided, let's say, the legislative approach of the laws addressing electronic commerce since they started to be approved actually in the mid-90s. As I understand it, okay, because I mean it's a bit difficult to define. It's not that there's no definition, let's say legal definition of the principle is something that is based that is at the basis of legal rules, for example, addressing electronic signatures, electronic documents in general, some electronic documents in particular, such as negotiable documents or transferable instruments. And there might be different understandings of the principle, but what I would say is that it basically tells that electronic means deserve the same legal recognition and the same effects as paper means, to the extent they provide for the same functions that make paper documents relevant for the law.
Okay. Okay,
That could be a bit of a theoretical and abstract definition, but for example, if we apply this to possession and control, control is supposed to be this for digital documents the same as possession for paper documents. Now, the function of possession has always been to identify the holder, and therefore for control to be achieved in a digital document, it should as reliably identify the holder as well of a digital document. So let's say to be the functional equivalent of possession, right? So this is a way to apply it in our context.
Okay, okay, very clear. Thank you. Mas, I have a question for you. The lack of interoperability between different EBL platforms is a challenge when it comes to using EBL. Could you explain why?
Yes, it is a challenge, and it's also a challenge that's being worked very hard on solving, but I'll get back to that. It can be a challenge for some, but not necessarily for everyone. If you have a very close working relationship, you have a bank you work with, you have a counterpart you work with, and you can get everyone on the same platform, then it's not a problem. But if you try to put yourself in the shoes of, let's say, a bank that has a lot of different clients, all of these clients want to use their own system or whatever system they have chosen to use. That can be a problem for the bank because they now need to train their staff in everything. It would be much easier if we had interoperability, because that would mean that anyone can choose whatever platform they prefer, and then an electronic bill of lading would be able to transfer from one system to another. So it would solve a lot of practical issues, and it would solve the challenge of, for example, a bank not wanting to train their staff in 5, 6, 7, or however many platforms their clients want to use. But it is something that's being worked really hard on. And actually, I saw today our partners in the FIT Alliance from DCSA has managed now to do an actual transfer, so a fully interoperable electronic bill of lading, where it started on one platform and ended on another platform. So we are getting there, solving that challenge, and I'm really pleased to see that DCSA has managed with their partners to get that done.
Okay, thank you. There is a question. For to order BL, how the endorsement process will be concluded under the electronic bills of lading? Who would like to answer this question?
I can give it a go, but basically it's electronic bills of lading and paper bills of lading are not that different. You just have to think about it in the way that everything is now done within a platform. So that's sort of my immediate take on it, unless it was more the legal complexities of it that was the question.
Okay, if the participant can say if is happy with the answer, otherwise he can ask. You're welcome to ask another. Okay, he says thanks. So thank you, Mas. Javier, you already touched upon the question, but what do you see as challenges really specific to South America that would prevent the wide use of electronic bills of lading? You already started talking about that.
Yeah, well, the situation as I see it is, a lot of times we discuss at the regional level whether we need more, legislation or to improve our legal frameworks or whatever. But to me, it seems like really, I mean, that's not the big issue in a way, because for instance, in Colombia, you have, the way somehow paved to use the electronic BL. So to be honest with you, I don't think the key issue here is, to have more legislation. In some cases, probably that's the case, but not in all countries, as it's usually, you know, posted. And I think so. First of all, we need to address this in each case, you know, case by case, separately. Each country has different reality. But then something I think we have in common in South America is that we need to work very closely with our institutions to persuade them sometimes that there is no really need to have any modification in our local legislations. That would be the case, at least in Colombia, my jurisdiction, because I think sometimes here, you know, our institutions are, you know, full with people who basically think that we cannot use the document until we, you know, kind of do something with our legislation. And so for me, the first issue we need to address is to go to them, explain the situation, explain the legislation, and show the doors that we sometimes have to actually use the electronic bill of lading. That's one issue. And then we need to closely cooperate with the, you know, international institutions such as BIMCO and others to, you know, spread the message across our local institutions and governmental agencies, including probably customs as well, which is obviously very critical in that regard, so that, you know, they are very aware of the international developments that are in place, you know, for the use of these kind of tools, and basically to spread the voice that, you know, sometimes people just think that just because you're not having a paper-based document, you are running some kind of risk, but kind of it's going to be the other way around, right? Because sometimes when you have the electronic document, it could be even much more secure, you know, the information, if, you know, the platform is using blockchain or some other kind of technology. So I think we need to go and talk with governmental agencies, bodies, and spread the word. See what's the specific case in each country. Probably in some cases you will need to adapt somehow the legal framework, but to me, seems like really that's not the big issue sometimes, like it is the case in Colombia.
Okay, fantastic. Well, if we don't have more questions from the audience, I can conclude this first SNIPit3 live conference, and would like really to thank you so much, Manuel, Mas, and Javier, because, well, it means a lot to me that you said yes for the first live conference and for this challenge of speaking very briefly about complicated topic. Thank you for your time. Thank you for your expertise. And to the audience, stay tuned because there will be other live conferences from SNIPit3. Thank you so much. Bye-bye.
Thanks a lot. Bye-bye.